MSW Media.
The rule of law is not just some lawyer's turn of phrase. It is the very foundation of our democracy. The essence of the rule of law is that like cases are treated alike. That there not be one rule for Democrats and another for Republicans, one rule for the powerful, another for the powerless, one rule for the rich and another for the poor, or different rules depending upon one's race or ethnicity. To serve as Attorney General at this critical time is a calling I am honored and eager to answer.
So now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Welcome to episode 184 of Clean Up on Aisle 45. It is Wednesday, July 31st, 2024. I'm glad we got through this month. I'm Allison Gill.
And I'm Pete Strzok. Got a lot to cover today, including a continuance of Steve Bannon's We Build the Wall fraud trial, the results of the DOJ Inspector General investigation into the reduction of Roger Stone's sentencing recommendation that you might have missed with all the news going on, and DA Alvin Bragg's memo opposing Trump's immunity claims.
Yeah, that's a big one. We also have Judge Engoron refusing yet again to recuse from Trump's civil fraud case. We have a couple of updates on Rudy Giuliani and Mark Meadows, and we are another step closer to replacing Louis DeJoy as the Postmaster General. But first, it is Hall of Fame Patron Day here on Clean Up on Aisle 45. So thanks to our Hall of Famers, our most ardent supporters, including Steve Towell, Maria Tovar, Janine Igora, Maris Lawson, Veterinary for America 2024, The Tyrant We Deserve, Jeffrey Kincher, David in Brooklyn, Hypersonic Wiener Missiles Mom. So this is a dachshund that gets the zoomies, the Hypersonic Wiener Missile. Meg Alexander, Laura Saba, Deborah Kirby, David Chandler, and boy, would I love to be the bus driver. Thank you all so much. You know, if you sign up to be a patron for Clean Up on Aisle 45, you can choose whatever name you want, as illustrated by what I just read there. And you can also get invites to things like our meetup and our meetups and our galas and our Zoom calls. You'll also have first access to VIP meet and greet tickets for live shows. You know, Pete and I and Andy McCabe, Glenn Kirshner, Brian Greer, and Dana Goldberg are going to be in D.C. on August 16th. And then, of course, we'll be in San Francisco, me and you, Pete, and Olivia Troy on August 24th. So you get VIP meet and greet tickets, first access to those. And then, of course, you get these episodes ad-free and you get them early. So thank you so much for supporting independent media. If you want to sign up, you can do it at patreon.com/aisle45pod, AISLE45POD. And Pete, before we get into the rest of the news that we just talked about, I would be remiss if I didn't ask you about this. Quote, on Friday, Pete Strzok's lawyers announced his $1.2 million agreement as attorneys for both sides notified a federal judge in Washington that the privacy-focused portion of that dispute has been resolved. Quote, this outcome is a critical step forward in addressing the government's unfair and highly politicized treatment of Pete. This is from your attorney, Pete. He goes on to say, as important as it is for him, it also vindicates the privacy interests of all government employees. We will continue to litigate Pete's constitutional claims to ensure that in the future, public servants are protected from adverse employment actions motivated by partisan politics. Pete, congrats.
Yeah. Hey, thanks very much. Look, this is a long time coming. We filed that lawsuit back in 2019 and did a tremendous amount of work. And, it's certainly vindicating. I wish there was a way that rather than the Treasury paying that it would be possible to get Donald Trump or some senior members of the Department of Justice to foot that bill instead. But, again, like Eitan's statement highlights, it is, I think, a win for, government employees in general. And it does point very much to what, we could expect if Trump is reelected, because there's a lot of theorizing about, what might he do? Well, we know through not just me, but any number of folks exactly what he did. And so this sort of speculation about what does he mean, what would he really do? Well, we know it. And I think, the nice thing about the settlement is the amount was significant enough that I think there's no question about the wrongdoing that DOJ engaged in. There's frankly, no amount of money that kind of undoes, kind of the hell that came out of that. But it is nice to have it done. My employer, I still have, that was for the release of the text and violating the Privacy Act. I still have 2 counts remaining on wrongful termination based on First and Fifth Amendment violations. So, anticipate we will continue litigating that. We've submitted dueling schedules for the remaining claims. We're proposing to have the cases fully briefed. In other words, the parties don't go in and submit motions for summary judgment to ask the judge either, hey, look, rule in our favor because you don't even need to have a trial. And the government will say, hey, look, throw these out because there's no way they're going to prove them if we go to trial. And back in response to that, and then response to the response, and a final fourth sort of response to the response. So that we've proposed should wrap up by early November. The government's asking for something that wraps up next year. And again, this is before it even gets to the judge saying either I'm going to dismiss these or I'm going to rule in favor or I'm going to set a trial. So there's a long road ahead. But, at the moment, I'm happy. And, thank you. It's just, and again, for listeners, maybe some of you, right after I was fired and thinking about this lawsuit, went out and did a GoFundMe to gather enough money to hire attorneys to file this. So, this is a victory for every one of the amazing folks who chipped in to that effort as well. So I can't, it was extraordinarily humbling at the time, the amount of support and people donating to that. And, they're the ones who made this possible. So, this is thousands of folks looking at the abuses of the Trump administration and chipping in to make this result possible. So I'm super thankful.
Yeah. Well, congratulations, my friend. And we'll be following the 2 counts that are going forward. And, you mentioned the Treasury. I just want to make something perfectly clear to everybody. This cost to the taxpayers is a cost incurred by Donald Trump's bad behavior and Rod Rosenstein's bad behavior. This is on them. And so we have to all think about that when we go to the polls. I know we're all going to vote the right way, but, this isn't just like, money that's coming out of the government for no good reason. Rules and policies were violated. So, and laws, the privacy laws. So we have to think about this. And at least this is how I frame it in my head. Because I see people on social media, taxpayers are going to have to pay this. And those are all MAGA Republican people who are mad about that. But this is what your guy, Donald Trump, and his posse cost us. And it's just add it to the pile of things that they did that cost us money, lives, 401ks. It's preposterous to try to put it in, to think of it in any other way than that. You know what I mean?
Yeah. And it's, we've talked a lot about, how Trump is going after those who can least afford to give money, the mom and pop red state Republicans, MAGA faithful who chip in probably way more than they can afford in many cases to him, which in many cases isn't even going to his campaign, is going off to pay his legal bills. But, what we don't talk about a lot is all the other costs that his unlawful and alleged unlawful behavior has caused. And if you think about the entirety of Jack Smith's team, if you think about all of the people in Fonnie Willis's office, if you think about all the people in Alvin Bragg's office, if you think about all the people in the states of Pennsylvania and Arizona and Michigan who have investigated and then charged people associated with the false elector plot, those are all public servants. Those are all people who are being paid by the taxpayers, either federally or of those states. And, 2 things. One, so you were paying listeners to allow these investigators and prosecutors to build these cases, which if Donald Trump had not been such a, in my opinion, repeat felon, you wouldn't have to be paying it. And 2, it's not like there's a lack of crime to investigate and prosecute. They are doing this instead of doing other investigations and prosecutions. It is a zero-sum game. If they are investigating and prosecuting Donald Trump, that time they're doing that, they are not investigating white-collar crime, violent crime, foreign counterintelligence, counterterrorism, you name it, it comes at a cost. And so I don't think if you sort of try and holistically look at the cost of Donald Trump and being an absolute dirtbag, it's extraordinary. And notwithstanding, and again, add on to that list, every single time he has to get a booking photo done or show up in an initial appearance or go to court, and he flies on his little stupid gold-plated airplane, and he has a procession of police vehicles and stopping traffic and causing everybody to be late. All of those costs, all of it is just an extraordinary burden coming out of the taxpayer, coming out of the American economy. And when you step back and think about all the permutations of how much this man is sucking away resources that might be more productively used elsewhere, it's staggering.
Yeah.
Yeah.
And besides all of the money, Pete, that you brought into the coffers of the U.S. Treasury through asset forfeiture over the years, I think probably makes up for anything anyway. So, if you want to do a ledger of all of the money Pete has made for the Treasury versus what this case just cost to the Treasury, you will see it's very lopsided in favor. You're in the black, is what I'm saying. All right. Thank you, Pete. Congratulations. And we've got some news to get to. So what's first up? Where should we start?
So let's go to New York, right? Let's go to DA Alvin Bragg's memo opposing Trump's motion to vacate his felony conviction on immunity grounds. Now, Allison, you wrote about this in your Substack, so we're going to use you and Bragg's filing as a source for the discussion today. You wrote, as we all know, the captured Supreme Court ruled that presidents enjoy absolute immunity for core powers, presumed immunity for official acts, no immunity for private acts, and that any official act cannot be used as evidence against them, which is bananas. And as we all know, Donald was convicted of 34 felony counts of falsification of business records to interfere in an election in the Manhattan DA's hush money case. Now, pursuant to the Supreme Court's awful ruling on immunity, Donald filed a motion to vacate his conviction on the grounds that some of the evidence and testimony used in the Manhattan trial is subject to presidential immunity. The judge postponed Donald's sentencing from July 11th to September 18th and called for briefs. On the Cleanup on Aisle 45 podcast, we discussed that Donald had little to no chance here for two main reasons. First, these were private acts. Cutting checks to your former fixer to pay off an adult film actress for keeping her story quiet to impact the outcome of your election as a candidate for office that you don't yet hold is clearly a private act. Now, Donald filed for immunity in this case over evidence and lost, and then abandoned his appeal.
Yep. We talked about this, Pete. Listeners will recall, we have long said over and over that even though a lot of pretrial motions to dismiss that we discuss here and on the Jack podcast seem silly or early or weird, they have to be made to preserve your right to appeal should you be convicted. And the pretrial motions, they're like placeholders for later appeal. So if you don't raise it at first, you cannot raise it later. And the fact that Donald failed to appeal his loss on his earlier immunity motion in this case kind of precludes him from appealing it now. At least that's what Bragg is arguing. It's one of the things he's arguing. And Pete, you and I said we would wait to see if he made these same arguments that we talked about, and he has. Plus, one more that we didn't think of. Reading here from the filing from Bragg. The criminal charges here exclusively stem from defendants' unofficial acts, conduct for which there is no immunity. Although the Supreme Court also restricted the consideration of certain evidence of official conduct for which presidents are immune, that ancillary holding is also inapplicable here. For one thing, Trump failed to preserve an objection on immunity grounds to most of the evidence that is the subject of his current motion. And in any event, all of the evidence that he complains of either concerned wholly unofficial conduct or at most official conduct for which any presumption of immunity has been rebutted. People who have been listening to our podcast, my other podcasts, reading my stuff, for a long time now know that I love an even if, right? For example, when Mo Brooks wanted the Department of Justice to represent him in a civil case against him for January 6th, the DOJ said, your speech is not an official act because you were campaigning. And even if the court decides the speech was an official act, it can't be part of any federal employee's job to overthrow the government. Now, I'm paraphrasing here, but that was like the big even if for Mo Brooks. And now the DA here has two even ifs, saying these were private acts. And even if you don't think they were, he didn't appeal. And even if you don't think it matters and you think these are official acts, they still aren't immune. So it's like a double even if.
Yeah. And so the question then is, well, what evidence does Donald want thrown out as immune? And this, again, going back to Bragg's filing. Defendants' evidentiary arguments based on official acts immunity are largely unpreserved. Specifically, defendant raised immunity objections to only 2 of the 6 categories of evidence that are the basis of his current motion. Hicks' testimony about statements by defendant while he was president of the United States, and the admission of defendant's 2018 OGE Form 278E. Defendant raised no immunity objection to any of the other categories of evidence or to other testimony by Hicks. This other evidence accordingly provides no basis to set aside the verdict. And as Ambassador Norm Eisen points out, that knocks out, as a matter of law, his late objections on the testimony of Trump Secretary Madeleine Westerhout, Michael Cohen, Trump's social media posts, and most of the Hicks testimony. It leaves us with just 2 categories of evidence. Now, the first is Hope Hicks's testimony about her chats with Donald in 2018 while he was president. About that, Bragg writes, as a threshold matter, defendant is wrong to assert that Hicks' testimony categorically concerned official acts based on core Article 2 authority for which defendant is entitled to absolute immunity solely because she was acting as the White House communications director at the time. The Supreme Court rejected any such categorical approach to absolute immunity based on a government official's role in its recent immunity decision. For example, the court held that not all of a president's discussions with his vice president would qualify as official conduct subject to absolute immunity. Likewise, although the court found that defendant was absolutely immune for the alleged conduct involving his discussions with Justice Department officials, including the Attorney General, that ruling did not turn on those officials' governmental role alone, but relied as well on the court's finding that the subject matter of their discussion was the potential exercise of a president's conclusive and preclusive authority to investigate and prosecute crimes. So, stepping back, basically, Donald is saying that, look, because Hicks was Meadows' chief of staff, all of their chats are immune. But the Supreme Court explicitly said the immunity isn't based on the role, but also on the content of what was discussed. And Allison, here's the even if that you were talking about. Second, even as to Hicks' testimony about her discussions with defendant in 2018, all of those discussions related solely to unofficial conduct. So even if the court decides for some reason that any discussion with the chief of staff, these are discussions about unofficial acts. And then finally, that leaves the OGE filing, Donald's publicly available federal financial filing. Here's what the district attorney has to say about that, with lots of even ifs. 1, the obligation to file this form isn't limited to presidents. Even if that didn't matter, it's about private finances, so no official acts. Even if it reflected official conduct, it's a public record. And even if none of that matters, we brought it in through Jeff McConney, who isn't a government employee. And even if you decide that this is an official act because Donald's filing is speaking to the people, he didn't object to it at trial. And then all of that covers the objections that you and I talked about. But, as you noted, Alvin Bragg adds one more, something called harmless error. And this is the granddaddy of all even ifs.
Yep. Thanks for leaving this one for me, because they say if for some reason the court doesn't accept all these arguments, quote, there is no reasonable possibility that the limited evidence discussed above, even assuming that it should have been excluded, meaningfully contributed to his conviction. The extensive grand jury evidence cited above far exceeds the required prima facie showing of every element of falsifying business records in the first degree, and no part of the grand jury record described above relies on any official act's evidence. Because the indictment is overwhelmingly supported by admissible evidence, the defendant's belated and unpreserved effort to dismiss the indictment should be rejected. So that's the big even if of all of them, right? Even if none of what I've said previously you agree with, the final here is something called harmless error, meaning even if you think this evidence shouldn't have been brought in, it wouldn't have made a difference in the verdict.
Right. And I think looking at this, I mean, it seems clear to me that I think the Bragg has a very strong argument. This isn't, this won't get appealed until it can't be appealed anymore. So I don't anticipate we will, have a conclusion to this until much later on. But I think at a minimum, I wouldn't be surprised to say, nope, this is good, and go ahead and have the sentencing, before the end of the year. But we'll see. I mean, the good news is this is, again, all of these things are storylines that are continuing, facts that are out there, and events that are yet to come. So we'll see what happens. And this, again, there will be action on this prior to the election. So that's another kind of helpful data point to, remind folks that Donald Trump's a convicted felon.
Exactly. And that'll happen in September. Because even if he wants to appeal this, if the judge comes back and says there's no immunity here, which I think he will, the sentencing will still go forward on September 18th. And any appeal after that would probably not even start to be briefed until close to, if not after the election. So we'll keep following it for you. And we need to take a quick break. We have a lot more to get to, so stick around. We'll be right back.
Hey, welcome back. We have more Hall of Fame patrons to thank, including Mitchell, Scott Griegs or Griegas, ATX Polar Bear, Charles Jones, Roberta Reed, Star Lanus, A Dinosaur in Dental School, Je suis fatigué, Karen Sherman, Fran Reichenbach, Triple G, and Patty B. Thank all of you so much for your extraordinary support. Truly, truly so thankful for your continuing support of the program and letting us put this out every week and going above and beyond. So just truly, truly humbled by your support, and thank you. So let's stay in Manhattan. Now, you'll recall that Trump filed yet another motion for Judge Engoron to recuse from the case that awarded the New York Attorney General Tish James a $454 million, with an M, disgorgement in her civil fraud trial against Donald Trump and the Trump Organization. Trump had alleged that Judge Engoron engaged in prohibited communications with a real estate lawyer about the case before his decision was rendered earlier this year. Now, you'll remember that public reporting indicated that these prohibited communications were actually just one former judge approaching Judge Engoron and telling him to go easy on Trump. Now, perhaps unsurprisingly, Judge Engoron has issued his order saying he will not recuse. Engoron in Thursday's ruling said he was accosted, that's his word, accosted by that person, a guy by the name of Bailey, while leaving the courthouse one random day in February. The judge described the 90-second incident as a nothing burger from a landlord-tenant lawyer ranting, and said that he did not base any part of his rulings on what Bailey said. Engoron writes, I did not initiate, welcome, encourage, engage in, or learn from, much less enjoy, Bailey's tirade. I did not base any part of any of my rulings on it, as Bailey has outlandishly, mistakenly, and defamatorily claimed.
Wow.
Now, I feel like, I should read this in a Gene Wilder, like Willy Wonka voice.
I said good day.
but two, when you have a judge, if you were practicing law in the state of New York, and you have a judge writing in a court filing that you have engaged in defamation, I'm going to go out on a limb. I'm not a lawyer. Let me preface it with that. But I'm going to go out on a limb and say that's probably not good,
right?
for your standing with the court and perhaps the New York Bar Association. We'll see. But the judge also said he was unaware of any investigation by the Commission on Judicial Conduct, saying he has not been contacted by the review group.
Yeah. And let me read some of this ruling because it's fantastic. This is Judge Engoron. Sometime in or about February, several weeks before I issued the order, at the end of the business day, I left my robing room in the courthouse at 60 Center Street, rode an elevator down to the main floor. There, on the outskirts of the famous rotunda, Bailey accosted and started haranguing me about Executive Law Section 6312. He did not relay any alleged facts. Prior to that time, I considered Bailey a professional acquaintance and a distant friend. His sudden appearance and vehement speech took me aback, and I simply told him he was wrong. He trailed after me, still droning on as I descended the judge's stairs to the street level. I entered my vehicle without saying another word except maybe goodbye and departed. For approximately 3.5 years prior to this unpleasant occurrence, starting in September 2020, I had researched 6312 intensely and had issued many rulings, including preliminary injunction and summary judgment decisions based on it. I certainly did not need a landlord-tenant lawyer ranting about it. I did not initiate, welcome, encourage, engage, or learn from, much less enjoy Bailey's tirade. I did not base any part of my rulings on it. That's where the defamatory accusations came in there that you just read. He goes on to say the entire 90-second incident, after 3.5 years of studying and being immersed in 6312, was, to use the vernacular, a nothing burger. I would have forgotten all about it by now had Bailey not attempted to burnish his reputation as someone who could influence judges, which would be unethical and possibly illegal, but of which Bailey nonetheless publicly boasts.
Oop.
Yikes. Due to extensive news coverage of this trial, passersby often recognize and confront me on the street, at parties, in parks, restaurants, and public transportation. Sometimes their unsolicited words are complimentary, sometimes they're derogatory. Never do they affect my rulings. As with my forced encounter with Bailey, I feel no need to report these fleeting incidents.
And he concludes with this. As no grounds for mandatory recusal exist here, it is up to me and my conscience to determine whether this 90-second unsolicited diatribe about a law with which I was fully familiar and in which I was fully immersed by a non-party and non-expert who conveyed no facts in any way affected my adjudication of a dispute over which I had presided for 3.5 years, during which time I had already issued several dispositive decisions. I hereby definitively state that it did not. Of all of that, which is lovely. I love his description of Bailey as a landlord-tenant lawyer.
Yeah.
Because we all want to call Alina Habba a parking garage lawyer, which is what truly, literally, I'm not making this up. That's what she did. Yeah.
Yeah. We call us when there's an oil spill with Jeffrey Clark, right?
Yeah.
Same kind of thing.
Exactly. With this thing, there are enough people out there in New York that I think, whether Mr. Bailey has some Barr investigation or potential sanctions heading his way, when a judge is saying it's defamation or defamatory, when a judge is saying, hey, he's saying he did this, which would be unethical and possibly illegal, I think he might be treading on some tenuous ground. Now, it might take, New York years, like it seems to take every bar organization years to move on it, but this was the right outcome, and good for Judge Engoron to point out the lunacy of the entire file.
Yeah, and it was this judge who ran after him and talked to him, and then this lawyer, this tenant landlord lawyer ran after the judge, talked to him, then went over to Trump and said, "We had discussions. We should file a motion." It's so stupid. And by the way, when this reporting first came out, that is exactly what you and I predicted happened. And that is exactly what happened. I mean, we're 5 for 5, Pete.
The entire discussion was go easy on Trump. That's it's just nuts. Frustrating.
All right. Well, we have more news to get to. We're going to do that, but we're going to take a quick break first. Everybody stick around. We'll be right back. Hey, everybody, welcome back. It's Hall of Fame Patron Day, and so thank you to Mr. Halfspeed, Christine G. Passion, Kimberly D. Stephen, Harris for President, excellent, Suzanne Ashworth, Christine Tachner, Dr. David, January 20 baby, me too, Berta 5078, D. Gill, Sharon Tukalski, Jason Berzoska, and Pete Strzok's Ball Tanning Salon. So thank you very much for supporting the show. We have 2 stories for the C block today. This one is first up from the Washington Post, and this one makes me mad. I really don't like Michael Horowitz. The Justice Department's Inspector General on Wednesday blamed ineffectual leadership and not White House interference for the softening of Roger Stone's sentencing recommendation in February 2020 after his conviction for lying to Congress. The report upheld an account by then Attorney General Barr, but also found that line prosecutors' suspicions of political meddling by Trump's administration were not unreasonable. Well, gosh, thanks. At sentencing, frontline prosecutors initially notified the court that they wanted about 7 to 9 years. That would be appropriate under the federal guidelines. Within hours of that filing, and after Trump tweeted the request was disgraceful and a miscarriage of justice that could never be allowed, Bill Barr overruled the trial team. A second memo signed by supervisors retracted the recommendation, prompting all 4 prosecutors to quit the case. Some of them later said publicly they believed they were undercut by department leaders to protect Trump's longtime ally, Roger Stone. They would be right. I added that part. Stone was ultimately sentenced to a little more than 3 years behind bars, which Trump later commuted anyway, sparing his prison time. So there we go.
Yeah, I share your frustrations with the DOJ Inspector General. I think he has a habit of playing for the political forces and understands full well that his authorities and funding comes from the Congress and will play to that. And I'm sure he would vehemently disagree with that. But it sure seems to me that something like this is. There was a lot of wrongdoing in there. I mean, it talks about, in particular, ineffective leadership at the D.C. U.S. Attorney's Office. It talks a lot about, some of the decisions. And the weird, Allison, going back, some of the weird thing about this is like when it comes to DOJ and DOJ attorneys, the IG does not have authority to investigate allegations of misconduct. That's left to DOJ OPR, which if you don't like DOJ IG OPRs, they feckless. I mean, they rarely drop the hammer on anybody. The reports they do release are anonymized, so you have no idea. I mean, it's so vague, you can't even tell what the hell they're talking about. But in this case, the only reason the IG looked at it is one of the prosecutors related to the Stone prosecution went into Congress and gave sworn testimony where he made allegations of misconduct. And so the hook that the IG used is like, oh, this former Stone prosecutor lied to Congress, and because that would be a potential criminal violation, that gave them the hook to look into this. But I think there is a lot of really nasty stuff, particularly reflecting on the Barr, senior levels of the Barr Department of Justice, that really gets buried in the report. And having been on the receiving end of the IG sensationalizing certain conduct within the FBI that I thought was over-sensationalized, and as well as many others, this is kind of the opposite, in my opinion. It seems to like, there's really bad stuff, but it kind of gets buried under, 10 layers of like, well, the big takeaway that there was, no improper action in reducing Stone's sins. So it's a little frustrating, but.
Well, they got rid of, I believe her name is Jessie Liu, and at the U.S. Attorney's Office there, and they tricked her into doing it. Like they had earlier offered her a job in a different agency, and she turned it down, saying, I'm not resigning. They pressured her to resign. She said, I'm not doing it. So then they offered her a really nice job over at the Treasury, and Trump nominated her for that job. And as she's taken her box of personal effects across to the Treasury, he withdraws the nomination. And so she's out of a job. They shoved Tim Shea in there against the Vacancies Act. And he is the one who came in and did these dirty deeds for Trump and Barr. And then, of course, he couldn't stay past 180 days or something like that, or 90, some specific amount of days without approval from the D.C. Circuit Court. And so that was not going to happen. So then they got rid of him and put in Mike Sherwin, who continued to approve the watering down of Flynn's stuff and Roger Stone stuff, and continued to support that on behalf of this administration, and then went on to basically almost screw up the seditious conspiracy case for the DOJ against the Oath Keepers. And by going on 60 Minutes and saying we're looking at seditious conspiracy charges and like flapping his gums, which all had to be cleaned up. And the fact that Merrick Garland was able to bring those charges and get a conviction despite Mike Sherwin trying to screw it up is a justice miracle as far as I'm concerned. So that was just a whole shit show. Fuck all those dudes. Pardon me. I know we don't try to swear too much on the not bonus episode, but it's so frustrating as we followed all of that so closely on the Mueller, She Wrote podcast for so long. All of that just treachery and bullshit and lying and corruption, and that he's probably going to get away with it is extremely frustrating. So anyway, enough of frustrating talk. What else do we have today?
So the second story for the block brings back a long since shelved segment called Comings and Goings.
Yes, that's right. Early in the Biden administration on this show, we would discuss who from Trump world was getting the axe and who was being appointed or hired by the Biden administration. We called it Comings and Goings. That largely died down after 2 years, but it's back today.
Yeah, and you might ask, well, we're at the end of July 2024. How on earth could it be that there's anything like this on this date, so many days after the end of the Trump administration? Well, this comes from Joyce Vance's Substack, which is amazing, and you should subscribe to it if you don't already do so. Joe Biden nominated former Florida Congresswoman Val Demings to the U.S. Postal Service's Board of Governors. He also nominated Republican businessman William Zollars. Now, the USPS Board of Governors consists of 11 people, 9 of whom are nominated by the president and must be confirmed by the Senate before taking office. The board is rounded out by, and now you know where we're going, the Postmaster General and the Deputy Postmaster General. In March, President Biden appointed former Labor Secretary and Democratic Mayor of Boston, Marty Walsh. All 3 of the recent nominees are still pending Senate confirmation. Governors serve 7-year terms. Now, the good news is that this is an essential stop towards replacing Louis DeJoy, Trump's Postmaster General, who is still in place. DeJoy is a Trump loyalist and donor who was appointed with no qualifications to run the post office effectively, and he hasn't. DeJoy put measures in place that he claimed were designed to cut costs, but that in practice seriously impaired mail delivery. In one notorious move, he dismantled sorting machines. This resulted in massive backlogs and serious delivery delays. It just so happened that led to major slowdowns in swing states just ahead of the 2020 election that resulted in tens of thousands of ballots arriving too late to be counted. It's frustrating that DeJoy is still in place as Biden's term in office comes to a close. In part, that's because procedures around the appointment of Board of Governors members are meant to preserve the essential non-political status of the Postal Service. But they boomeranged here. The postmaster is selected by the board, and that appointment is not subject to Senate confirmation. Only the board can remove the postmaster, but no more than 5 members of the board can belong to the same political party, and governors can only be removed for cause, some sort of proven bad acts or extreme neglect for their obligations. The 7-year term means that it has taken this long for Biden to have sufficient openings to change the balance on the board.
See, I was under the impression he could just change them. You can't.
No. And, the crazy part is conservatives had the audacity to claim DeJoy, and this is still Joyce, Vance writing this, to claim DeJoy had somehow redeemed himself because mail delivery had improved. He even tried to ingratiate himself with climate change proponents by supporting the use of electric vehicles. But people who recall the way DeJoy politicized the Postal Service, including postal union employees, continued to call for his replacement.
Yes. Now, Joyce continues, in 2021, Biden appointed 3 governors to open positions. All were confirmed. He appointed 2 more members in 2022. That left 2 Trump appointees on the board. So these new appointees, Demings and Walsh, round out the Democrats Biden hoped to replace on the board. The Republican, Zollars, who served previously, is being reappointed. So you can see what a delicate dance it takes to get to the point where replacing DeJoy is a realistic proposition. Although presidents must appoint under the set political restrictions, the individuals they appoint are up to them. And one of the Trump appointees, who was technically a Democrat, supported DeJoy. So once confirmed, these most recent appointments should make it possible to replace DeJoy. It can't happen soon enough, she writes. Beginning this week, although it will likely take a bit longer, we will watch for confirmation of these new governors to see how quickly they take action. It's easy to lose track of an issue like this with everything else that's going on, but the effectiveness of our democratic institutions depends on it. The ability of government to function on behalf of all of us, not just a ruling class, whether it's the Justice Department, the Postal Service, or any other agency, depends on the commitment of leadership to public service. When agency leaders are part of a cult of personality, we move away from being a democracy. Something Donald Trump understood was that installing his loyalists gave him the potential to corrupt these agencies, even if it was just around the edges. But what happened at the post office with DeJoy during the 2020 election is yet another cautionary tale about how dangerous Project 2025 is. One part of it, which we've discussed, Joyce discussed on Substack, involves converting the federal bureaucracy from a cadre of career professionals into a group of conservative sycophants. Imagine an entire agency focused on interfering with the delivery of ballots instead of just the guy at the top. By the way, it's not a theoretical risk. This evening, a federal judge in Mississippi rejected a lawsuit brought by the RNC and the Mississippi Republican Party designed to overturn a Mississippi law that would allow ballots to be counted as long as they're postmarked on or before Election Day, even if they're received up to 5 days afterward. Given the way the mail is working these days, that only makes sense. It's the rule in many other states, she says, but now the decision by Judge Louis Guerola, I believe is how it's pronounced, it faces review in front of the notoriously conservative Fifth Circuit Court of Appeals, which means it's impossible to predict what the rule for mail-in ballots will be in Mississippi come Election Day. We need a Postmaster General who will make every effort to ensure swift delivery of Americans' ballots instead of impeding it. And by the way, military votes by mail.
Mm-hmm. Yeah,
So,
and it's funny because a lot of, the discussion of Project 2025 and all the horrible stuff that's in there, it's interesting to watch, the rise of public awareness of how awful Project 2025 is and how, it's become so toxic that even Trump is trying to distance himself, I think, unsuccessfully from it. But it's one of those, I see Harris and her campaign focusing on kind of more nuts and bolts issues, whether it's taking away access to women's reproductive health care, whether it is, the makeup of the Supreme Court and the prospect of, further eroding, abortion rights. Those are issues that kind of convey to voters in a way that, as both of us former government employees, we can look in there and say, hey, this is really profound, the way that, you can gum up the workings of government. But trying to, I think, for the average listener, for the average voter out there, when you start talking about, replacing federal employees under Schedule F and the corruption and the way that would really damage the kind of levers and operations of government, I don't think people understand how profoundly bad that could be, right? I mean, if you stop getting your mail, if all of a sudden you start buying rotten meat because the USDA has been wiped out and replaced by sycophants, it is the role of the U.S. government day in and day out in Americans' lives, federal interstate highways suddenly, with potholes every 500 feet. It is hard to convey how profound the damage would be to another Trump presidency. But I do think I agree that trying to explain that in a short campaign snippet or speech is pretty hard to do. So I understand not necessarily focusing on it, but it terrifies me. I mean, that is one of the things when you look at just what Trump was able to do his first term, and he wasn't really thinking through how to do it. He didn't understand how to do it. He clearly does now. I mean, that is the entire premise of Project 2025, to not waste time, not waste a year plus, and just totally take over the government with loyalists, and things would fall apart in ways that it's really hard to understand and envision. But it's awful. And DeJoy is a great example of that.
Yeah, truly. He just wants to dismantle our democratic institutions as much as he can. He is suing like I think Gretchen Whitmer because he's mad. He's suing the Veterans Affairs or Whitmer there about the VA, because the VA has you can register to vote at the Department of Veterans Affairs. Veterans and disabled veterans can register to vote at the Department of Veterans Affairs, and Trump wants to stop that from happening. I mean, that's how wicked and horrible he is. He doesn't want you to be able to vote if you're a member of the military. He wants to delay the ballots. He wants to have all of the Republican state legislatures file rules that say we don't accept late mail-in ballots, and then he'll go in and have his buddy destroy sorting machines. This guy DeJoy made money off of Trump properties, by the way. Like money, lots of real money, and owns a trucking company who wanted to privatize the Postal Service using his trucks and his company. Bad people. bad people who don't want you to vote. They want to dismantle democracy and democratic institutions. It's just awful. So I didn't know. I thought Biden could replace any of these governors on the board at any time. No, he had to wait. And that is why DeJoy, for all those asking, because we did a little segment on this maybe a year and a half ago when we found out he was working with the labor secretary on electrifying the fleet. And that's kind of why everybody was leaving him in place. That's not it. It's because this nominating process, you have to wait. And so that's where we're at. So we've got it now. As soon as these folks are confirmed by the Senate, and watch the Republicans try to muck it up and delay it, because they know this is part of their plan to interfere in the elections. So we'll see how it goes. We'll keep an eye on it for you. All right, we got a few more stories, but we have to take one last quick break. So stick around. We'll be right back.
Hey, welcome back. We have our final round of Hall of Fame patrons to thank, including at Dirt Road Dims, Clover's Tree 73, Kirkland J. Bateman, Greg Kreimer, Catherine Gilbert White is totally awesome at her job, Ren Special K. Kadu, Lisa Rollison, Nathan Dorn, Tiffany Trump was adopted, Devil went down to Georgia. He was looking for an election to steal. He was in a bind. He was way behind by 11,780 votes. And please don't read this on the pod. We don't need a call out. Thanks for what you do. And no, thank all of you so very much. Really deeply, deeply appreciate your support. So at the end here, it's time for some lightning round news. After losing in the 11th Circuit, Mark Meadows has taken his Fulton County motion to move his case to federal court to the Supreme Court. You'll recall that Judge Pryor in the 11th Circuit denied his motion, ruling that 1, he isn't a federal officer because he no longer works for the government, and 2, it's not the executive branch's job to administer elections. That's for the states. So, ordinarily, when you have Judge Pryor in the 11th Circuit saying, no, you're done, I would think he's done. But God almighty, who knows what's going to happen when, Sam Alito and Clarence Thomas and everybody else gets their hands on this.
Yeah. And Justice Thomas gave him 2 more months to file this. So that's why it's coming so late right now. All right. Next up, Rudy Giuliani told the criminal court in Arizona, where he's indicted this month, that it shouldn't impose residency requirements on him because he's like George Washington. And the court would have never done that to George Washington. Listen, here's what he wrote. He said, Mr. Giuliani is a great American hero and a patriot whose endurance, swift action, and determination inspired all people in the United States during a time of great national turmoil and stress. Would anyone think it necessary to require George Washington to reside in a particular state and not leave that state without permission of the court if charges were filed against him in that state during his life? The answer is an emphatic no. And the same is true for Mr. Giuliani. He literally put that in a court filing.
Oh, my. Did he use AI to? Oh, my.
This is what the judge said. The court's reviewed the motion. Good cause for granting the relief is established by the fact that defendant Giuliani is not a resident of Arizona, and the state doesn't oppose the granting of the request relief. No one opposed this. And he's out here like, I'm like George Washington on 9/11. Nothing further was required from the defendant to secure this relief. You didn't have to file your George Washington thing, is basically what he's saying. He goes on, he says, yet the motion did not end with that. Pages 4 and 5 are filled with assertions that are not germane to the issues before the court. Counsel is reminded of certain provisions of the rules of professional responsibility, which restricts lawyers from engaging in conduct that's prejudicial to the administration of justice. Consistent with the principles of equal protection under the law, Giuliani is not entitled to greater or lesser consideration of requested relief because of his alleged status or stature. Any suggestion to the contrary goes against all concepts of justice. Going forward, the court expects all parties to limit their filings and arguments to cognizable claims that are supported by relevant facts and law. Like you've seen those memes, like nobody, absolutely nobody. Rudy Giuliani. Yeah, Rudy. I'm like George Washington. You can't give me... Oh, my God.
I can say a little, not germane. I can say like, goddamn Germans got nothing to do with it. For those of you not old enough to remember Smokey and the Bandit, that would be a pull from there.
You but again, twit. Some of my favorite insults came out of that from Jackie Gleason.
Yeah.
Sheriff Buford T. Justice.
So let's stay with Rudy, because the D.C. Bar is extending his law license suspension pending the outcome of his disbarment proceeding. You'll recall the court made the recommendation to the D.C. Circuit Court of Appeals, and they have yet to render their decision. But they have issued an order stating his license will continue to be suspended while we await the final ruling. Rudy was permanently disbarred in New York just weeks ago.
Yep. So New York, that's done. We're still waiting for D.C. Court of Appeals to rule on the D.C. permanent disbarment, which I'm sure they will. We just have to wait. But in the meantime, he still can't practice law in D.C. And lastly, Steve Bannon's We Build the Wall trial was set to commence with Judge Merchan presiding in September. But that has been rescheduled for December 9th, presumably because he's in jail, prison, federal corrections institution, low-level security. He didn't get club fed. He's really mad about that. But anyway, that will happen December 9th. So Merry Christmas to us, right?
It's absolutely right. And I don't know how long. I mean, again, if you think it won't be as long, I don't think as Trump's trial, but it could take a couple of weeks. And you're right. I mean, I think, can they get it all done from jury selection to the trial before the holidays? We'll see. Stay tuned.
They'll probably do jury selection and then do opening statements and then maybe recess until after the first of the year. But who knows? By then, by the way, December 9th, when he goes, we will know who the next president of the United States is going to be. Time is weird like that when we think of it about, what else was going on. I was thinking that the other day because I was rewatching Game of Thrones because I'm really into House of the Dragon. And it dawned on me that I started watching Game of Thrones. We were all watching it together during Obama's first term in office. That's how long
First term.
First term. Yeah. First term in office. Anyway, everybody, thank you so much. And thanks again to our Hall of Fame patrons. I look forward to seeing some of you and some of the other patrons at the DC Gala on August 17th. We're going to have another party. Dinner and drinks are on us. We were able to get everybody who didn't get to go to the first one, who wants to come to the second one. We were able to accommodate everybody, and plus some folks who didn't sign up to go to the first one. So I'm really excited to see everyone. It's going to be truly, truly fun. And then, of course, we've got the show the night before at the Hamilton. Tickets they're going fast. So you're definitely going to want to grab those if you're thinking of coming, because they are selling quick. And we only have a handful of tickets left for our San Francisco show, Pete, at Swedish American Hall on August 24th. That is going to be at the end of the DNC, the Democratic National Convention. And if you think the momentum is amazing now, wait until then, because between now and then, we're going to have a VP pick. We're all going to rally around that. And then we're going to have the convention. It's going to be incredible. The energy on August 24th, that weekend, is hard for me to imagine right now. But I feel like we've already surpassed the energy that we had in 2008. And so I'm really looking forward to it. And I think it's going to be a big, fun party at that show in San Francisco.
Yeah, for sure. I mean, I guarantee you the entertainment will be a step higher than Kid Rock and Hulk Hogan. I'm going to go out on a limb and pronounce
at our show or the DNC.
That right. Well, both. Frankly, I was talking about the DNC.
Okay, so you need to wear 2 sleeveless shirts and rip the first one off.
No.
Oh, come on, man.
Oh my God. I just can't. It is so horrific. And then who was the adult film actress they had, influencer, they had, I mean, it was just like, you gotta
Amber
be kidding.
Rose? Is
Amber
that her
Rose,
name?
right? Yeah. Come on, man.
I don't even know who that is, honestly. But I'm also old. I don't know who any of the musical acts are in Saturday Night Live anymore. So don't go by who I've never heard of. it's not a good gauge. But anyway, yeah, I'm at the point where I ask Alexa what time it is, and I pull a muscle doing that. So that's how old I am.
Yeah, we'll all be able to enjoy it. You know what we won't be doing is we pour a beer or favorite beverage prior to tuning in to watch the convention. We will not be Steve Bannon staring at the commissary list trying to decide whether it's worth $2.50 to get a hot beef summer sausage. I thought those were free.
Hot summer sausage. To be found in JD Vance's couch. Okay.
Yeah, and we texted a little bit back and forth, you and I, about this offline. I cannot wait. I suspect there is Oppo coming on JD Vance as we progress through the summer and the fall. That is going to be interesting. So stay tuned.
Oh, they're just getting started. You don't release your good Oppo until October.
Stay tuned. Stay tuned.
Yeah.
A man with 3 names, 4 names. There's a lot going on there. That's all I'm going to say right now.
Yeah, he's changed his names more times than JD Vance changed couch covers. Anyway, no, you know what? We can't not joke about the couch, because if you've watched John Oliver this week, he talked about how the rumor was so widespread that the Associated Press had to put out a correction saying the Associated Press had a headline that said JD Vance did not have sex with a couch. Then they had to pull that down. And here's why. Because they can't say definitively whether or not he has. They can only say it wasn't in this particular edition of this book that he wrote, but they can't definitively say with 100% certainty that he never has. So that's just this is the these will never not be funny to me.
No, and it's snowballing, right? Because now everybody is going out and looking, and they're like, oh, guess what? They found out from a Rolling Stone article from October 2022. An article entitled JD Vance has a burnt monkey testicle problem, which again goes into the fact that, he has his investment, his at the time investment company funded a biotech firm that does testing on live animals, and apparently was horribly staffed, and a technician's poor, performance led to literally some test monkeys having their testicles burnt. But you can't.
And then he searched for women and dolphins.
And dolphin. Yeah, it's just come on. So I think we're just getting started. Weird. So hey, there you go.
Weird and dangerous. I think it was it Charlie Sykes or somebody who said a clown with a flamethrower still has a flamethrower.
That's right.
Don't forget that. All right, everybody, we will be back obviously this weekend for our bonus episode for patrons, and then next week. You can also listen to the Daily Beans all week. And of course, there's a new episode of Jack out. If you haven't listened to that, we go over all of the things you will need to prepare for when Jack Smith's appeal of Judge Cannon's stupid decision dismissing the documents case comes out. We're going to prep you for that on the latest episode of the Jack podcast. So, Pete, thanks very much. And we'll see you all next week. I've been Allison Gill.
And I'm Pete Struck.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.